Thank you, Your Honor. Your Honor, the fact of the matter is, whether Mr. Risner and his group like it or not, the government may impose reasonable time, place, and manner restrictions on speech even in a public forum. The restrictions got to be content neutral, got to be narrowly tailored to serve a significant governmental interest, and there have to be ample opportunity for alternative means of communication of information. We've heard no end of testimony here today about what went on in Armory Park and how they're followed on Facebook, and more to the point, the public forum, the sidewalks are always available. And you heard testimony here today that they actually left the park, stood on the sidewalk to avoid the citation. I submit to the court, if you want to be there 24 hours a day, then you walk the sidewalks. That's what better way. Wouldn't that get you on the news? Wouldn't your friends on Facebook be even more amazed to see at 3 o'clock in the morning a group of people parading around Viente de Agosto Park in support of this movement? So there is ample opportunity to do that and still work within the confines of the law. Our city code is content neutral, Judge, and therefore it's subject to less scrutiny. The city ordinance at issue is not enacted or was enacted or proposed because we disagreed with the defendant's message. This ordinance has been around for decades. It empowers the city to administer the parks for the good of all people. And throughout this testimony, I was struck today how this group and these people have decided that to put their interests before the interests of the general public and to substitute their judgment for the way the parks should be managed for the elected officials. And they've offered no evidence that they have any expertise in how to manage parks. So when the elected officials
have a right to speak.
I'm sorry?
They have a right to speak.
Absolutely have a right to speak.
If I'm wrong, and I think that there should be no government at all, I have a right to go out.
Absolutely have that right. 16 and a half hours a day. You just can't do it in the park during the time the park is closed. So the code's silent on the point of views expressed by the defendant, Your Honor. It's absolutely content neutral. Through Mr. Risner's pleadings, he mentioned more than once that it never envisions political talk. That's exactly right. It's blind politics. It's there to administer the parks for the good of the people and the citizens of Tucson. It applies to any park. And it applies to any person or group that are using the parks. So it's administered in an even-handed manner. As far as being narrowly tailored to a significant government interest, Your Honor, the regulations for the use of the public forum and assure the safety and convenience of the people are not inconsistent with civil liberties, but are one of the means of safeguarding the good order on which those civil liberties depend. That's from the Thomas v. Chicago Park District, Your Honor. It's in our plea. I invite the court to read that. The government has a significant governmental interest in keeping these parks attractive and in intact condition, readily available to the people who wish to see and enjoy them by their presence. That's Clark for the communication of creating nonviolence. Again.
Do does Clark talk about a time limit that they cut off?
As a matter of fact, they do, Your Honor. Okay. On the National Mall, they wanted to camp overnight. That was, prohibition against that was upheld in that very case.
I'll read on to Jesus.
This code does not burden more speech than is necessary. It only closes the park from 10:30 till the morning hour. At the night. The sidewalks, as I've said before, always available. So at least 2/3, a little more than 2/3 of every day, they can go there, they can protest, they can have their tents. I thought it was telling that we're insistent on 24-hour occupation, but yet when Ms. DeCamp was on the stand, she said there were only 2 of us in the park. So it seems to me, as Mr. Crow, it seems to me that one of the witnesses said that these tents are props. It seems to me that an empty tent serves the same purpose. That's the case. But the point, more to the point, Your Honor, is the city has the right to regulate the parks.
Okay, so
and we've done that in a content-neutral fashion in accordance with the
I spoke
Constitution.
an ordinance and that these folks can put their tents, leave their tents tents at night, but not occupy the tents.
That's what they have done, Your Honor, whether or not we permit it.
Okay, I haven't visited, put signs all over, that's okay, right? Any expression of free speech can be.
They have done that in contravention of the law, Your Honor. It doesn't matter what I say here today.
They can't put their tents up.
They have put their tents up. They can't be in the park after 10:30. They can't camp in the
Right,
park.
but they can put their tents up in your,
And take them down, sure.
no, and they can put signs up all over.
Sure.
You just want them out by 10:30.
I don't want them out. That's what the city council wants.
That's what the Parks Director wants.
Well, the city council appointed the park director and delegated to him the authority to administer the